Your Honor, I would like to mention item number 4 from the daily list. We are seeking adjournment with the consent of the other opposite parties, and we have filed the advance adjournment application also yesterday. Yeah, Charlie.
May I please, Your Lordship? Lordship, in item number 21, my lord, I have filed one affidavit, my lord, as per.
Want to call for it?
Yes, yes. Obliging.
May I please, Your Lordship? Lord, I beg to mention for listing of a matter for motion.
Want to list it?
Listing. Of that.
Item 1 for motion.
May I please, Lordship? My lord, this petitioner has died on,
Petitioner died.
yes, 2028,
Uh,
21.
So do you intend to substitute the legal heirs?
My lord, so my prayer would be to set aside the order because we have everything.
Okay, how can you set aside?
Because
If the man has died no longer, in whose petition do we set aside? Can you set aside on a petition of a dead man?
My prayer is unless his order remains in force.
Mr.
Then
Mahmood,
his
that
legal
is
heirs-
the reason why we are asking you, do you intend to substitute the legal heirs?
Actually,
If you don't intend, it is up to you. But no order can be passed on a pending petition of a dead man.
no, my lord, I think one judgment is there.
That it can be passed. Let us see which judgment says orders
No.
on a petition of
If
a dead man
separate-
can also be
If
passed.
separate proceeding is made against them, then they will face the trial. Trial is.
Mr. Mahmood says that an effective order can also be passed in a pending writ petition where the petitioner had already died,
No, I am not on.
and that there is a judgment or upon that proposition.
If separate proceeding is.
And the judgment may be produced before the court. When do you want?
That, yes, one dead person, Mia Hussain, the other day, your lordship set aside his order.
No,
Mia Hussain.
no, we did not.
Then let it be fixed.
You are, let's say you are wrongly informed by someone.
No, I conducted the case.
Let us see. Mia Hussain.
Mia Hussain.
Let us find out where it was done.
Last week.
Please give the citation. It's a very serious thing you have said. Mr. Mahmood further said that in case of a repetition of Mia Hussain, an effective order had been passed in a repetition of a dead man. The records of Mia Hussain be produced before the court. Yes, this Monday.
When will it?
Monday.
Monday, yes. Yes, I will.
Mr. Mahmood, be a little careful before you make submissions. Unless somebody had not informed the court that the man had died, we cannot pass any order in a petition of a dead person because the petition itself has abated. It no longer exists. So you have made a very serious thing that in spite of that, let us see the order. We'll call for that file, why it happened.
Which was that?
And if it has happened, we'll so much recall it also.
The order is there, Lordship.
Let us see.
Lordship has been taking a different stand altogether.
It's a consistently.
Yes, Lordship.
I don't know why Mr. Mahmood is saying that. Let us
I
check.
remember that Mia Hussain alias Beshan Ali.
Yes, you are right. Let us check up. If it is wrong, we'll be questioning you.
The last part.
Let us see why we passed that order. Mr. Mahmood, read the first line of the cause title. Please have it. Give it to Mr. Mahmood. And be more responsible in making your statements. You are a very senior counsel, so we expect some more responsibility before you make a submission. Read the first line
The
of
death
the.
of, let
No.
me, and I say, let me see.
Therefore, we asked you a question, do you intend to substitute the legal heirs?
Lordship had even said the heirs would
That is totally different
Take the-
circumstance. The
take
legal
this,
heirs are before the court.
prove their father's citizenship. I remember, Lordship.
Yeah, you can give back the order. You did not read
Yes,
the whole
my
order.
lord, here.
You need not read the whole order.
Para
Please
four.
read the-
We accordingly interfere and satisfy the common opinion dated 30.
Mr. Do we have perused the order in case of the repetition filed by Mia Hussain? It is noticed that in that repetition, the legal errors had been substituted before the order was passed. But in spite of pointing of the order, Mr. Mahmood still insists by referring to para 4 that on a petition of a dead man, the impugn order had been interfered. Mr. Mahmood to file a personal affidavit showing cause as to why an irresponsible submission had been made, and that too contrary to the records of para 4 of WBC 914/2020, list on Monday. Next item.
Monday.
Item two.
Carefully notice our order. You'll be in trouble, Mr. Mahmood, I am telling you. And don't take the court proceedings so lightly.
My submission may be withdrawn, my lord. It is can.
Why should you withdraw? You filed an affidavit to withdraw your submission. These are all live proceeding. Everything is on record. It's a
Yes.
video recording of the entire proceeding, mind you.
I will
In the
say-
initially, we offered a very fairly offered you, do you intend to submit the legal errors? And you are saying, no, this court has passed order on the petition of a dead man. When we produced the order before you,
No, I-
you were
I
still
insist
insisting,
that there should be separate proceeding against these persons.
do whatever you do,
There is, I will satisfy on that point, man.
do whatever you do, but you have to file your affidavit on your
Yes.
irresponsible statement,
I'll file.
or we'll refer to the bar council. Mr. Mahmood, you insist to contest this?
Lordship?
Do you insist to contest this matter in this manner?
No, I'll take instruction from the party. Thereafter, I will also clear.
No, no, on the question frame, please read out the question to him.
Report.
Read him. First, understand the purport of our order. You'll be in trouble if this order is retained. Why so casually?
So far this.
How can a
that
so
person is
senior
also-
counsel like Mr. Mahmood be so casual before
Let me
the
allow to substitute them that.
you'll make a responsible submission when you record it, withdraw it? What will the youngsters learn? That you can play with the court at any time you feel like? Can this be an acceptable behavior of a senior counsel? And that too, the court is very fair with you. First question we asked is, do you intend to substitute the legal heirs? And you went on to dragging the matter in a different direction. Mr. Shigdar, please explain to him what is the circumstance. I think he has still not understood.
It's
very difficult to make him well understand.
So the law will make you understand then.
Not on that. my lord.
Then the law will make you
Everything
understand.
may be withdrawn, my lord.
You
That
file an affidavit for withdrawing it. We'll take up after some time.
That we are two. Because court number one, there is a one matter.
Whatever you do, it's up to you.
Fix
Before
for
rising of
Monday,
the
you
court.
can do
Monday,
it.
my lord.
Lordship
It
has
will
already
be
fixed.
on Monday.
But you'll be in big trouble if this order remains, I'm telling you. It's a
That's why
judicial order.
I said that this may be treated as withdrawn.
How can you treat it as withdraw when it is said? So you file an affidavit that you had not made the statement submission,
That I'll take on Monday.
not Monday, today.
Today, my lord.
Otherwise, how can you withdraw the order if you sign it? For Monday, we have to sign the order
Then at 2 PM today.
before we rise.
I'm like,
And Mr. Mahmood, see, we are so fair to
Yes,
these
sir.
litigants. Why are you trying to overreach the court? Why are you trying to just spoil the system? And what did the court ask you? If the petitioner had died as the right to sue may survive, do you intend to substitute the legal heirs? And see the direction where you're taking their proceeding now. Don't take advantage of our leniency. Don't take advantage of our big-heartedness. It's unfair. You confront the court saying that there is a prior judgment of this court where an order in a petition of a dead man has been passed. When you take out that order, put it across to you that it was not in a petition of a dead man, but it was in a petition where the legal heirs had been substituted. After reading the order, you again reiterate saying that in para 4 you have done it. Is this a responsible behavior?
My lord,
See, we are very sorry to say all this.
when everything may can be done, I take apology for this.
And you spend 15 minutes for this purpose, for nothing. Mr. Mahmood, please for an adjournment to explore as to whether the legal heirs of the petitioner are required to be substituted. But please, it's a request from the court, don't indulge in this behavior. You will not gain anything out of it. But you're likely to lose many things. It's better you take what has been offered to you in a good, fair manner.
My lord, this matter has, lordship has passed the order. But one thing, my lord, even lordship granting permission, I have several judgments where that person order is not there. But it has been directed to the police to file a separate proceeding against the living person. That order is there. That I only wanted to place.
Sorry, you cannot.
Okay.
That will be a order that will be passed in a petition which is already abated. No order can be passed. Because on the very day that this writ petitioner died, this petition does not exist in law anymore. So there will be even if it is passed by somebody, it will be a wrong order. It cannot be done. Only way out is we close this petition, giving liberty to the legal heirs to file a fresh writ petition, or the legal heirs get themselves substituted. Third option is this order becomes final, imbued order. It will always exist on record.
Obliged.
And there are no fourth option before you.
I'm sorry for this.
Just item 2 is appearing.
Item 2.
My lord, in this case, my lord, parent's name is in 70 voter list, lordship will find at page 46.
বাবুগঞ্জ নাম দেওয়া হয়ে আছে স্যার বাবুগঞ্জ নামকে টাইটেল তো দেওয়া হয়ে আছে
I think some instructions were called for in this matter, no?
I think no.
Yes,
No.
we have some instructions,
I
but I
don't
do not know why. मतलब order लिखा है ना.
আমি মাকক এক্সামিন কৰিব লাগে যে কেয়াৰটি চাওঁ ডিমাণ্ড কৰি দিয়া সেইটো কাম মাকৰ লগত ভোট আছে
मातर लोगों
97 ভোটাৰ লিষ্টত নাম আছে চাইছে ফুলতে motion of ideas. I think this is because of the copy paste of before admission.
My lord. My lord, page 46, my lord. Vernacular at page 47. parents' name appeared, my lord, in the voter list of 1970.
Who is this?
My
Father?
lord, Noimuddin is the father, Jagun Nessa.
Noimuddin Bewa.
My lord, my lord, kindly see the, my lord, the 77 voter list. This is more interesting, my lord.
What's wrong here?
Some mistake, my lord, on the part of the authority.
What's the actual name? Noimuddin?
My lord,
What should be the actual name?
actual name is Noimuddin, my lord.
Only Noimuddin.
Noimuddin, my lord.
So he's the father anyway.
Well, he is the
Jaigun mother.
Mother is Jaigun Nessa.
Okay, Larkusi.
My lord,
Hmm.
my lord, he is voter with mother, my lord. Father not surviving, my lord.
Okay.
Lordship will find at page 7.
Jobimuddin.
Josimuddin.
Josimuddin.
Yes, my lord.
Josimuddin name along with mother. Where is it?
Mother at page 78, my lord. 2014 as well as my lord 17 voter list also. 2017 voter list.
Jaigun Nessa
Jaigun
and
Nessa,
Josimuddin.
Josimuddin. In 17 voter list, it pays 80.
Same village.
Same village, my lord. So, my lord,
Larkusi.
my lord, my prayer is that
You,
mother may be examined, my lord. That was
Uh,
not done, my lord.
mother.
Mother, my lord. Mother is still surviving, my lord. I have instruction today morning, my lord.
2017.
Yes, yes. 2017,
You produce all the in-between voters list.
my lord.
Will allow you
My lord.
produce
Yes,
all the
sir.
in-between
We'll
voters
produce, my
list
lord.
because
We'll
all of a
produce.
sudden,
Yes,
after
sir.
many years, somebody. Yes, my member. Does it say something contrary?
Something that you can't solve. No, provide this instructions that come usually they don't start with COVID.
Is the microphone off? Just check up.
I have no idea why these instructions have come. Usually we don't get such detailed instructions. I'll just share it, Lordship. Has been verified with the election branch.
Complete Parvez comments on the
It's very surprising and Lordship will, the statement of the petitioner at page 24, he himself states that he is from Bangladesh. My actual residence was at Faridpur district of Bangladesh,
Where page?
page 24, Lordship.
24.
His statement is there.
My lord. This statement we have challenged, my lord.
You challenge your own statements.
My lord. Because this statement has been recorded without taking signature of that person. This is
Hmm?
false report, my lord. That is my allegation against
Lordship,
this.
if the petitioner's statement is false, that means the Gampura statement is also false. At page 26 is the Gampura
Yes.
statement.
Yes, that statement recorded without taking signature.
Maybe. Let us find out.
Records must be there, Lordship.
Evidence 21 to 87.
My lord, those are, my lord, the complicacy in the inquiry stage.
Maybe Mr. Sigdar will sort it out, don't worry.
My lord. My lord, one election
Ah,
officer was examined, my lord.
No, I understand. We'll look into everything, though.
My lord.
Let's find out. Where is the, can you find out the evidence of this one? Jasimuddin? Mhm. That's fine.
My lord, Josimuddin's statement we have annexed in the writ petition, page 24 and 25. my
But
lord.
definitely his signature is not there. We may be right. It, tribunal, asked the tribunals to give a detailed index. All that they write, evidence, this, that, page 21 to 87. This is not an index. I can just spend some more time in preparing it. Because if they don't spend the time, our judicial time is spent to find out that.
Muslim judgment has been upon
It's better.
basically. Don't aside that.
Mhm. Or sent back to the tribunal. In course of the hearing, an issue had arisen as to whether the statement of Muhammad Jasimuddin whether in the statement of Muhammad Jasimuddin, the signature of the person making the statement had been taken by the tribunal. Mr. Shigdar raises an issue that it was not taken, and therefore a necessity had arisen to verify from the record, from the original statement in the records. But from the records, it is noticed that a summary form of the index is available, where written statement, documents, and evidences are stated to be from pages 21 to 87. Send back the record to the tribunal to resend it with a detailed index, so that the location of that statement can be so that the statement can be located. You
Right.
can't spend
My lord.
15 minutes of judicial time to find out from where it is. List after 2 weeks.
Well, item 3, my lord, we have to collect.
Madam Verma,
Yes,
retain this one. Very well.
Item 3.
My lord, in item 3, there is shifting, my lord. We have to collect, my lord, upline and downline voter list of SOR number 5
Mr. E.R. Shikdar states that there is a shifting of the petitioner from village
from SOR number 5 to Mohanpur.
Mohanpur, and therefore the petitioner would like to produce the upward and downward voters list of the 2 villages. That is the original village and the village to where the shifting had taken place.
My lord, develop.
List from 2 weeks.
Item 5.
Make the lordship. Lordship, in this case, lordship, the petitioner declared Indian in earlier, my lord, in the year of 2018, my lord. Subsequently, 2019, second proceeding start, my lord. You have made an application before this time,
Where is the 18 order?
18 order, my lord,
Page 30.
page 30. Read it.
Again, same thing in view of the above observation.
Yes.
What is the observation? Petitioner himself stated that so and so is the father so and so.
Did you-
Then they say that there is a voters list of so and so also filed.
Yes.
But where is the proof that so and so is the father?
DW2, my lord, is the.
Sorry,
DW2 is the elder brother of the petitioner, my lord.
we
Yeah,
have not understood what you are saying, please.
DW2,
DW2.
yes.
Who is DW2?
Elder,
In the earlier proceeding,
elder proceed,
where is DW2?
my lord, is Nelson, my lord. My
It
lord,
is only DW1.
DW on, my lord, proceeding, my lord.
In support of the oral evidence, DW once exhibited as many as 4 documents.
Yes,
That is, Rahimuddin's name appeared in the voters list of 66. Then voters list of 89 of some village is the 1897 voters list. In view of the above observation, what observation?
My lord, page 30, in last line, my lord. Page
Hmm.
30, last line,
Gone carefully through the entire material.
last, deducted to Abdul Barek.
Last line of page 30.
Page 30, 30A.
30. What is 38? DW adduced evidence also supported.
Yes, my lord.
Who is DW?
Elder brother of the petitioner, my lord.
Where is the evidence that he is the elder brother?
Lord, evidence, my lord, I don't annex, my lord.
These are the basic things you'll have to prove.
Yes, my lord, his, DW
See, anybody proceeded, he can easily come and make his own statement. Number one, X is my father. Produce the voters list of X.
Yes,
Say
my lord,
that this
I
is the voters
I
list of
voter
X.
list, I have a voter list, my lord.
Mr. Hassan, our
Page 16,
specific question is, where is the evidence to prove that that man is the father?
yes, my lord, petitioner father name, my lord, kindly come to the page, my lord, 12, my lord. Page 12, petition, name of the father of the petitioner is Rohimuddin.
What is page 12?
Voter list of 1966.
How do you know that Rahimuddin is the father? What is the difference between a false claim that Rahimuddin is the father and the actual real claim that Rahimuddin is the father? The difference will be sorted out if you bring in evidence to show that Rahimuddin is the father. We are just pointing out that material is not available on record.
Okay. My lord, I have a governor certificate also, my lord.
Again, the same thing. Ultimately, this is not a reasoned order. It is only a
Not a reason of it.
view being expressed. So how res judicata is applicable? So you better prove your case on merit, discharge the burden, we'll hear it.
No, I leave it to lordship, my lord, whatever.
Don't leave it anything to us. You are here to make your submissions. You are engaged by a client to make submissions before the court, not to leave it to the court. Res judicata can be made applicable, we reiterate it every day, only when the prior decision contains a decision. Decision under the law means it should be backed by reason and not backed by a view or feeling of some authority.
My lord, second proceeding, the petition, I am not declared foreigner, my lord. I challenge before declare foreigner, before submitting the WS, my lord.
If you are not declared a foreigner, then why are you
My
before the
lord,
court?
I have made an application before this tribunal to decide the matter regarding the res judicata, my lord. That was not considered, my lord.
Okay, that is the, we send it back, you get it adjudicated on merit. Hmm? Yeah, what is it? FA,
FA
Hassan and Council. Here, Burma, so video. The petitioner Razia Khatun. Sorry. Was referred to the Foreigners Tribunal number 1, Tezpur, for rendering an opinion as to whether she is a person who entered the state of Assam on or after 25/3/1971. The petitioner appeared before the tribunal and filed a petition dated 19/7/2019, making a prayer that the proceeding itself be dropped, as she was declared to be not a foreigner in a prior proceeding, being FT 14/2016, as per the final order dated 15/2/2018, passed by the Foreigners Tribunal number 1, Sonitpur. Accordingly, the order of the tribunal in FT case number 14/2016 dated 15/2/2018 was placed before the tribunal. Before the tribunal, the petitioner relied upon the judgment of the Supreme Court rendered in Abdul Qudus versus reported in so and so, wherein it was held that the principles of res judicata would also be applicable in respect of a proceeding under the Foreigners Tribunal. The learned tribunal, in the 4th paragraph of its order dated 24/12/2019, in FT case 2854/2012, initially resulting in registration of FT case 2012, took a view that in Abdul Qudus, there was a declaration by the foreigner, declaration as a foreigner by the Foreigners Tribunal, which was upheld by the High Court. But however, as the name appeared in the draft NRC, therefore, there was a contention that the order of the Foreigners Tribunal declaring him to be a foreigner should be set aside because of the findings of the NRC authorities. Accordingly, the tribunal arrived at a conclusion that the factual situation in Abdul Qudus and the present writ petition are different. And therefore, the paragraph 4 of the tribunal in its order dated 24/12/2019 is extracted as below. In Abdul Qudus, the Supreme Court had held that the principles of res judicata would also be applicable in respect of a proceeding under the Foreigners Tribunal. The said principle laid down by the Supreme Court was not related to any factual circumstance as may have been prevailing in the case of Abdul Qudus, but it appears more to be a general proposition that the principles of res judicata would be applicable. From such point of view, we are in disagreement with the conclusion of the tribunal in paragraph 4 of the order dated so and so. The petitioner in the present proceeding takes the plea that by an earlier order of the Foreigners Tribunal number 1, Sonitpur at Tezpur, by its order dated 15/2/2018, the same petitioner, Musammat Razia Khatun, was declared to be an Indian citizen. In the circumstance, the principles of res judicata requires the satisfaction of two conditions precedent. That is, the earlier proceedings must be between the same parties, and secondly, the earlier proceeding must have arrived at a decision between the final decision between the parties. As regards the second principle, that there must be a final decision between the parties in the earlier proceeding, we examined the order dated 15/2/2018 in FT case 14/2016 as to whether in the said order there was any decision by the tribunal. A decision is understood to be a conclusion arrived at by a judicial authority by giving appropriate reasons for arriving at such conclusion. Any conclusion that may have arrived without any reason under the law cannot be construed to have been a decision. In the circumstance when we examine the order dated 15/2/2018 in the FT case 14/2016, it is noticed that in the fourth paragraph of the said order, the tribunal states that DW2, that is the writ petitioner himself, had stated that she was born in the year 1964 in village Korokani under the Tezpur police station, and that the name of her father is Rahimuddin, whose name appears in the voters list of 1966 of village Korokani. It further states that DW2 Abdul Barik also supported her evidence. It is noticed that the DW1 referred in the said order is the writ petitioner himself, meaning thereby that it is merely it is a statement by the petitioner that Rahimuddin of the 1966 voters list of village Korokani is her father. DW2 is stated to be the brother. Accordingly, the tribunal was of the view that the oral evidence of the writ petitioner as DW1 had been corroborated by the voters list as well as the evidence of DW2. But what is noticed is that there is no conclusion arrived at that the Rahimuddin of the 1966 voters list of village Korokani is in fact the father of the writ petitioner, or that the DW2 Abdul Barik, who is claimed to be the brother, is actually the brother. In a proceeding under the Foreigners Tribunal, it is a general claim which is always made by referring to a person and claiming that person to be the father, or as a matter of fact to another person and claiming the other person to be a brother. But a mere claim does not, but a mere claim in the absence of any supporting evidence that the concerned person is the father or the brother, as the case may be. Last sentence. Would be insufficient to arrive at a conclusion as to whether The person who is claimed to be father, which in this case is Rahimuddin of the 1966 voters list of Koragani, or the DW2 Abdul Barek is the brother of the petitioner. Complete one sentence. Last sentence. Last sentence. And then third piece of the next sentence. In the instant case, no, I lost track of the sentence. Please read the whole sentence. I think it is not complete. Which in the present case is or the other person concerned is the brother, which in the present case is DW2 Abdul Barek. Sentence I don't think this is complete. Yeah, I think it's completed. Who in this case? Complete. Full stop. As in the absence of such material before the tribunal, in its order dated 15/2/2018 in FT case 14/2016, it cannot be understood that the tribunal had rendered a reasoned decision that the petitioner is not a foreigner. As we have not noticed any reason, they said they had passed any reasoned conclusion. In the absence of any reasoned conclusion, we are unable to accept that the order dated so instead WC is a final decision between the parties. In view of the above, the claim of the petitioner that the present proceeding is barred by the principles of res judicata would have to be rejected, and accordingly it is rejected. The petitioner may appear before the tribunal and prove her case on merit that she is a citizen of India. A petitioner to appear before on so and so.
Question.
Item 6.
May please your lordship. Lordship will kindly see the annexer 17 lordship at page 66 lordship. The order passed by the learned tribunal lordship at page 66 and 67 lordship will find that on 8/9/2017 OP is present and stated that she will not examine of DW2.
Page number?
Page number 67 lordship. 67, the translated copy.
Something wrong with the page. It's not with yours.
68 lordship. In 3 dates.
No,
lordship.
67, 68, these are order sheets.
Order sheets lordship. What happened lordship?
Two order sheets.
Before the learned tribunal, the OP was absent for 2-3 days and the learned Foreigners
Mr.
Tribunal,
Sarkar, what is your case?
Lordship.
Against which order you are before the court?
Lordship will find annexure 18, page 74, Lordship. Page 74, the impugned order, Lordship.
So you are against this order on what
Lordship.
ground?
Lordship, that OP was absent and whatever the exhibits were annexed by the OP Lordship before the learned tribunal, due to not examination properly, the learned tribunal declared foreigner.
Due to not examination properly.
Properly, some evidence, Lordship.
Who did not examine properly? Tribunal?
Lordship, from OP side, Lordship. The
Sorry?
petitioner, Lordship.
You could not do it, but you remain absent. How can you do it by remaining absent?
Lordship. Hence, the learned tribunal passed the impugned order. Even the
It is bound to pass the order if you don't come and appear.
Lordship.
So
But
now what is your case?
with petition, the learned council filed petition for absence, Lordship.
That is okay. Now what you want?
Lordship, if possible, Lordship, that the matter may be remanded back for further evidence,
How much-
whatever the
How much
petitioner
cost
may,
will you pay for the conduct in not
Lordship.
appearing before the tribunal?
Lordship. But petition were filed by the learned council, Lordship, but did not consider.
But you can't,
Lordship.
we've seen it. You can't go on filing petition after petition.
Lordship. 2-3 days she was absent.
Very well. How much cost will you pay? Go back. How much cost?
Lordship, I have no instruction, but they are
We
poor
don't go by
person.
instruction of the litigant.
Lordship.
We just asking, if you don't want, we'll impose it from our side. Yes, Madam Verma.
Lordship 17, the proceedings started and 13 adjournments were sought for till 19.
No, cost will be how much? We understand.
Lordship from 19, it's before this court.
So how much?
Lordship will fix up, Lordship knows.
They're poor person, Lordship. So
Yes.
some consideration may be
19 to
allowed.
20.
So if you had been
Anganwadi
a rich
worker
person, the cost
also.
would have been, say, 5 lakhs. Now if it is poor person, how much it will be?
They're poor person.
No, for rich person, it would have been 5 lakhs. So now for poor person, how much it will be?
Up to your Lordship. If considered Lordship, she
Pay
may
pay the minimum of the cost. Pay 5,000.
5,000, Lordship.
Heard, heard Mr. S.K. Sarkar, Learned Counsel for the petitioner, also heard the petitioner Archana Das was referred to the Foreigners Tribunal number
2, Lordship.
2 Bongaigaon at Obhayapuri for rendering an opinion as to whether she is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of case number BNGN/FP-2/APR/case number 13920/17. The tribunal rendered an opinion dated 27/11/2019, declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. The writ petitioner has raised the grievance that although she initially appeared before the tribunal and submitted certain documents, but the same could not be examined in a proper manner. And before the petitioner could avail such opportunity, the impugned order was passed declaring her to be a foreigner. We have perused the order dated 27/11/2019 of the tribunal, as well as the other orders from the order sheets that have been annexed to the writ petition. A reading of the order sheet makes it discernible that on several occasions, the petitioner remained absent and sought for adjournment without any acceptable reason. And it is only under such circumstance that the tribunal was compelled to pass the order impugned, declaring the petitioner to be a foreigner based on the materials that were already available before the tribunal. But from such point of view, we do not notice any infirmity in the order dated 27/11/2019 of the tribunal in case number so and so. But however, as the petitioner makes a claim that she be provided another opportunity to produce materials as well as to properly place the materials already
Submitted.
placed on record before the tribunal, we grant another opportunity to petitioner, but for the conduct of the petitioner in not doing the needful in her earlier appearance, the petitioner to pay a cost of ₹5,000 to be deposited before the DLSA, which district?
Bongaigaon.
Bongaigaon. Upon showing proof of the payment of the cost, petitioner to appear before the tribunal on so and so,
Highly obliged.
and thereupon order on merit may be passed.
Highly obliged.
Item 7.
May I please, your lordship?
Yes.
Reports. My lord, on last occasion, my lord, the report was submitted from the director, my lord, for your lordship, my lord. Regarding the, my lord, on last occasion, my lord, this case was listed on 26/4/2023,
We issued notice
my lord.
and also passed an interim order.
Yes, my lord, and the records were also called from me.
Records are not called.
Records were called. LCR was called from me.
And then,
And my lord, today the case has been fixed, my lord.
Huh.
My lord,
so you
my lord,
are you ready?
my lord.
Yes, sir.
Well, the father of the petitioner is my lord Kazimuddin and the grandfather is Asruddin, my lord. My lord will kindly have a look at page 29, my lord, the voter list of 1965,
Page 29.
29, my lord. Voter list of 1965 of grandfather and grandmother of the petitioner, my lord.
Page 29. Amiruddin.
Amiruddin, my lord.
He's the grandfather.
He is the grandfather, my lord.
Grandfather. This is of 65. Village Sohoria Farm. Nagaon.
Sohriba, my lord.
Okay. And Kariman is the grandmother.
Kariman is the grandmother, my lord.
Now, who is the father?
Father is my lord Kazimuddin, my lord.
Page number.
Page 33, my lord, voter list of 1971, my lord. This is an
Page 30.
33, my lord,
30.
annexure 4, my lord. Only Kazim is there, my lord. Kazim,
Kazim,
Kazimuddin actually.
son of Mito Amir.
Amir is there, my lord.
Village
Sohriba, my lord. Same village,
Sohoria Farm.
my lord, same village.
Okay. This is 71.
71, my lord.
So now which document will show that, what is this?
My lord.
Asiruddin,
Asar Ali.
Asaruddin is the father of Asaruddin is Kazim. Which
My lord,
document?
the voter list of 2005, lordship will kindly have a look, page 47, my lord.
Page
This is
47.
an extract copy of voter list, my lord, not certified copy. The name of petitioner, my lord, it appears at serial number 825, but D was put, my lord,
Page number 47.
47.
Asar
48 is
Ali
the-
Kazimuddin.
my lord.
This is of which village?
Same village, my lord, but the
Where is
extract
the
copy-
name of the village written?
name of the village is not legible from the, my lord, the copy, extract copy of voter list, next page, my lord, 48.
Sohoria Gaon.
Sohriba, my lord.
Sohoria Gaon.
Father's name appears, my lord, and the mother's name along with the sister and the petitioner himself, my lord, but D was put, my lord. Voter list of 2005, my lord.
Asar Ali. Yes, ma'am. Sorry, in the farm, they write down. Yes, ma'am.
1975. Along with the grandfather and grandmother, the father's name also identified because it's the same village. That was not.
My lord, that is an incomplete voter list, my lord, and the other,
You produced the complete
Yes, my
voters
lord.
list, not only complete, all the voters list.
my lord, all the voter lists are produced. Yes,
Or maybe just picked up the.
Mr. Hamad, there is a possibility that Kasim may have again gone back to Bangladesh and again reappeared
Oh, my
after
lord.
some time.
my lord.
So therefore, in between, his name is not there.
No, my lord, the other subsequent voter list, my lord, his father's name and mother's name appears, my lord, in the subsequent voter list.
You produce all the voters.
My lord, I'll produce it.
Kazim is a 30 something.
There's a discrepancy,
Like-
page is always there, my lord, in the voter list.
Discrepancy of how many years?
My lord, that I admit, my lord,
No, how many discrepancy of how many years?
that I cannot. say, my lord.
Yesterday, we came across a case, the daughter is older than the father.
My lord,
So
Yes.
these cannot be discrepancy. This has to be something wrong somewhere,
My-
or the person is not actually the father. But if suppose instead of 35, you write 40 somewhere, instead of 30, instead of 40, you write 37, these are maybe possible.
my lord, yes, my lord.
father's name is missing with his parents. And then in 75, the parents are there, but the father's name is missing. So you can produce this complete model, the same.
That's what I say. You
Yes,
produce the
ma'am, I
complete.
produced the complete. model.
Heard Mr. Jet Hamad and counsel for the petitioner also. The petitioner
Aswaruddin.
Asaruddin. When I produce the complete voters list, we put this observation for objection she will raise. We'll put it in our order. The tribunal to examine that aspect. The objection Madam Verma is raising,
My
we'll mention it in our order.
My-
And we'll also ask the tribunal to look for that aspect of the matter also.
my
Understand, you raise this thing and the tribunal will also look into this aspect. We'll put it in our order.
my-
Resulting in, where is the order of the tribunal?
Alternative page, my lord,
Yes, right.
71, my lord, annexure 14, my lord.
The petitioner so had been Asaruddin referred to the foreigners tribunal number 2, Morigao, for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of case number FT bracket D 100/09. The tribunal rendered an opinion dated 22/12/2022, declaring the petitioner to be a foreigner, being aggrieved the state petition is instituted in the writ proceeding. The petitioner relies upon the voters list of the 1965 of village Sohoriapam in the Nagaon district, which contains the name of Amiruddin, son of Besu at serial 251, and that of Kariman, wife of Amir at serial 253, and both are residing in the same house number 65. It is claimed that Amiruddin is the grandfather and Kariman is the grandmother of the petitioner. The voters list of 1970 also contains the name of Amiruddin and Kariman. Reliance thereafter is placed in the voters list of 1971 of village Sohoriapam, which contains the name of Muhammad Kazim, son of late Amir at serial 213, and is shown to be residing at the house number 73. It is claimed that Muhammad Kazim is the father of the petitioner. To substantiate the same, further reference is made to the voters list of 2005 of village Soharia Gaon bracket East, which contains the name of Kazimuddin, son of Amir at serial 822, Jaeda, wife of Kazim at serial 823, and that of Asar Ali, son of Kazim Uddin at serial 825, where Kazimuddin and Jabeda residing at house number 239 and Asar Ali at house number 240. It is claimed that as the name of Asar Ali, son of Kazim, appears along with Kazimuddin, son of Amir, in the voters list of 2005 of village Sohriya Gaon, and the name of Muhammad Kazim, son of Asar, appears in the voters list of 1971 of village Sohriya, the petitioner had discharged the burden under Section 9 of the Foreigners Act 1946 that he is a citizen of India. MSA Verma, Learned Counsel for the Home Department, on the other hand, has raised an objection that in the voters list of 1975, the 75, only the name of Amiruddin and Kariman Nessa appears, where the name of Muhammad Kazim, the father of the acclaimed father of the petitioner, is conspicuously absent.
Voters list of 71, Lordship. The father's name is there and the parents page 33.
But Mr. Hamad,
My
you look at page 33.
lord.
What's the name?
It's Muhammad Kazim.
Muhammad Kazim.
Son of,
Amir, my lord.
read complete.
Late Amir, my lord.
late Amir.
My lord.
Now read page 35.
My lord.
It's a voters list of,
75, my lord.
Ah.
My lord.
Amir was born again or what?
That I understand. my lord. Maybe there is something.
Lordship, I had just a
something
small
wrong.
submission to make.
So therefore,
My lord.
the name of Kazimuddin, that one disappearing, are they the same person? Maybe the village is same.
But as per the instruction, my lord, he's the same person. my lord.
No, no, not instruction,
Cannot
as
be.
per
my
the
lord.
claim made.
Something is wrong there, my lord.
Hmm,
Something wrong is there. my lord.
Golu.
Lordship, I want to submit something. This is the second time he will be going back to the tribunal. Lordship, may kindly come to page 72. His
72.
note- Yes, Lordship. The petitioner was first served a notice in 2010. He did not appear at all in 2011, and ex parte order was passed against him. 2011, 19, he comes to this court and takes a remand back again. He goes back and this proceeding starts and this gets over in 22. This period of 2010 to 2020 gave him ample time to come up with the documents. This is all a mixed match of documents, Lordship. And even if Lordship will peruse the opinion of the tribunal, very clearly, each and every aspect has been taken. The cross-examination of the Gaon Bura, the headmaster, everything has been taken, Lordship. On what grounds is he praying to go back now, Lordship?
Lord, the other supportive thing is that, my lord, the
What
deposition of my lord,
supportive thing,
the
Lordship, from
Let me-
2010 till date, how many
Lord, the
more
deposition of
documents
the
he wants to
concerned
manufacture?
headmaster of the school and the certificate issued by him. my lord. Lordship had taken into consideration on the very first day, my lord, regarding the my lord, certificate issued by the concerned headmaster.
Certificate. Now
Certificate,
we have lost confidence in
my lord,
certificate.
the deposition, my lord. In fact, my lord, a report was also called for, my lord, from the director. my lord.
Lordship, this is an opinion really to be read into, Lordship. Every aspect has been gone into. Lordship,
My
at
lord-
this point of time, Lordship may not like to remand it back, maybe said, take a call here only, but Lordship would like to go into the opinion, Lordship.
Why not? Yes.
Everything is there, Lordship. Every document has been discussed.
I will also rely upon the, my lord, the deposition made by the concerned.
But let us see the voters list now.
Voters list. is
Yeah,
a
Joyeda,
complete mix and match,
85
Lordship.
Joyeda and Kazibuddin.
My lord.
The election commission to produce the complete, to complete voters list of 1965, 1971, 1975, 1985, and 1989 and 1997. Of,
Lordship, his name appears for the first time in 2005. Only in 2005,
well,
Lordship.
let us see what 2005 of village,
Of,
Soharia Pam, stroke Soharia Gaon, all around this. Let us see. List on so and so.
2005, it is from some Dihing, Lordship. I'm not sure.
No, this.
Yes, it is the same thing.
Same.
There is a possibility the similarity of the names, but they may be different people also.
My lord.
Because 70 and 71, 71 is basically a corrected voters list where names did did not appear in 71.
Right.
So in 1970, this with the father that Amiruddin is alive. And in 1971, he says he is not there.
And only his name appears, no mother, no father, nothing, Lordship.
So 1970, 71 Vita Dibo, 70, 65, 70, 71, 75, 85, 89, 97, 2005. 70, 70, 71 both.
Right.
And make it a complete one. Huh?
My lord.
Item 8,
Was going to take the exam.
May I please allow?
Yes. Yes.
Lord, in this case, my lord.
You're relying some judgment.
Regarding faulty, my lord, reference, in the inquiry report, my lord, they are saying, we are, I am not illegal.
Forget
my-
about the earlier judgment. What do you mean by a faulty reference?
So,
First, explain us what is a faulty reference.
my lord, in the inquiry report, my lord, inquiry officer said that, my lord, I am not an illegal migrant and my date of place of birth.
So do you mean to say the inquiry officer has any authority under the law to take a decision whether the man is a foreigner or not?
No, my lord. He
Then
can,
what is the value of that report?
and on the basis of this, my lord, your lordship pass judgment.
It cannot be a faulty reference. The SP always has a discretion to make a reference or not, if he is not satisfied. The way in a disciplinary proceeding, even if the inquiring authority makes a opinion or recommendation that no punishment may be imposed on the person, disciplinary authority may differ with it, may not accept it. Same is with the SP. So there is nothing called a faulty reference. Otherwise, the law will be that the entire onus is now on the inquiry officer to take a call whether a man is a foreigner or not. You somehow please him by any means, he'll say he's not a foreigner, that means he become not a foreigner. Can't be the position of law. Then why do you have the Foreigners Tribunal? Why do you have all these acts? Why do you have all these rules for? That would have been the end of the matter. One policeman going and inquiring, whatever call, whichever direction he takes, that is the final. Now suppose I ask you the reverse question. Suppose the inquiring officer says that this man is a foreigner. Will it also be a final order?
No.
Final view? No. But if he is declared to be not a foreigner, that is the final view.
No,
How can there
my lord,
be?
this is not final, my lord. The SP, my lord, higher authority, my lord, they had option. Your lordship is granted them liberty, my lord. There is no word that they will not
No,
make,
no, now a reference is made,
Yes,
you
ma'am.
go and answer it.
they will not make fresh inquiry. They can make fresh inquiry also, my lord.
Doesn't matter. It's not required.
Lord. And
This inquiry is only an opportunity given. That's all. If the SP would have been convinced, then matter would have been different. But the inquiring policeman is convinced, that is not the final.
after, my lord, inquiry officer's report, my lord, no fresh inquiry was conducted by.
Not required. There's no
On the basis
requirement.
of
of law.
inquiry report,
Mr. Ali, you are on a wrong track. There is no requirement of law. You say, at what stage you have approached the court? It's a pending case or it's a,
pending case, my lord.
go and prove your
After-
citizenship.
After issue, my lord, notice, my lord, we submitted application that as per inquiry report, my lord, the reference is.
Sorry.
Lord.
Then we'll hear you. We'll pass a judgment on that. We'll pass a judgment on the legality and this thing. The effect in law of an inquiry report. We'll pass a judgment on that.
Now,
It's-
have given one judgment, my lord, that issue was discussed there, my lord.
Understand. We can discuss it once again. No difficulty. But if you say that the view of the inquiry officer is final, so if
No.
somebody is declared to be a foreigner, he'll be finally a foreigner,
It-
then we'll accept your submission.
Because
Then how
they had mechanism, they had liberty, my lord.
So how can the reverse be true, but the otherwise not true? But it is the SP who has the discretion not to make a reference.
Lord.
If SP had made a reference means he is not convinced with it. Okay. Again, this is a judgment following Manohara Khatun. Manohara Khatun is on some other aspect.
In Monwara's case, my lord, issue was framed, my lord, if the inquiry officer had founded the petitioner to be an Indian citizen by birth, was there any need for making reference before the tribunal? This was the issue, my lord.
Hmm. Here we see it. The superintendent of police, Dhubri, after proper application of mind of the report of the inquiry officer, came to the conclusion. This is what we are saying. SP can do it. But if SP, after applying mind on the report of the inquiry officer, feels that no, this is the case for a reference, he can always do it. He is not bound by the report of the inquiry officer. So we clarify that position. Monowar Khatun doesn't help you. Otherwise,
I have to prove otherwise.
you file an affidavit that the inquiry officer will be final. So we'll stop all this reference business. Wherever the inquiry policeman says he's a foreigner, he'll be a foreigner forever then. And there cannot be two different approaches. What do you want to do? Report came to the conclusion that did not appear to be a foreigner. So because of this, what we have written that DSP, which I think but here is it goes, he may be the fact that it is the inquiry officer who gave a report that he may not be a foreigner. This will have been provided for the inquiry officer. Inquiry officer, not directly, but according to the. No. Third, Mr. R.
Lordship, we will withdraw and we'll.
No, let us clarify this law. This is coming quite often.
Law.
Mhm. We'll clarify Monowara Khatun, we'll clarify this Malika and heard Mr. R. Ali, learned counsel for the petitioner, also heard Sharma or Verma? Sharma or Verma? Okay.
Ladies first, okay. This being very kind, Lordship.
Verma. The petitioner Aziz Mia was referred to the, where is the order of the tribunal, Mr.? What is it? Was referred to the Foreigners Tribunal number 2, Kamrup Metro, for rendering an opinion as to whether she is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number 165/2015, corresponding to IMDT case number 239/01. In the proceeding, the petitioner made an application. Where is that application? On which date you made it? To drop the proceeding?
That application we have not annexed.
I had made an any date, any idea?
So, yes, that is fascinating.
Had made an application before the tribunal with a prayer that the proceedings itself be dropped. Inasmuch as the inquiring authority in its report submitted that, write it inverted comma, submitted that during the inquiry, the petitioner could produced a voters list of 1966, which belonged to his father, to prove that he is not a foreigner. And accordingly, the inquiring authority had given a view that the petitioner is not an illegal migrant. In spite of such report by the inquiring authority, the superintendent of police border Kamrup, I think it was undivided at that time. Kamrup made a reference to the Foreigners Tribunal, resulting in registration of the aforesaid FT case number 165/2015. The petitioner being agreed by the order dated 23/2023, the tribunal was of the view that as the referral authority had suspected the petitioner to be an illegal migrant, post 25/3/1971, the prayer to drop the proceeding against the petitioner cannot be accepted. Being aggrieved, this writ petition is instituted. Mr. R. Ali, learned counsel for the petitioner, submits that what have we submitted?
My lord,
Submits that under paragraph 97 of the judgment of the full bench of this court in Muslim Mandal, you write the full particulars, he'll give you a versus so and so reported in so and so. There is a requirement under the law that before making a reference in comma, before making a reference, an inquiry should also be conducted by the authorities, giving an opportunity to the suspected person to prove before the authority itself that he is not a foreigner. By taking recourse to the provisions of paragraph 97 of Muslim Mandal Supra, it is the submission of Mr. R. Ali, learned counsel for the petitioner, that as in the instant case, the petitioner succeeded in proving before the inquiring authority that he is not a foreigner, comma, therefore, the subsequent reference by the Superintendent of Police border to the Foreigners Tribunal is a defective reference, and further, as the reference itself is defective, the tribunal, no jurisdiction is vested upon the tribunal to proceed against the petitioner. Accordingly, it is the submission that the conclusion arrived at by the tribunal in the order impugned dated 23/2023 is unsustainable in law. To substantiate his submission, the petitioner relies upon an earlier judgment rendered by the division bench in WPC 2674/2016. In Monowara Khatun versus Union of India and others. By referring to the said judgment of the division bench, it is the submission of Mr. Ali, learned counsel for the petitioner, that as the reference made by the Superintendent of Police border Kamrup was defective, therefore there is a requirement under the law to return the reference back to the Superintendent of Police border Kamrup. And in the circumstance, no reference before the tribunal would be maintained any further. M.S.A. Verma, learned counsel for the Home Department of the Government of Assam, per contra, submits that the provisions of paragraph 97 of the judgment of the full court rendered in Muslim Mandal Supra is only for the purpose of giving an opportunity to the suspected proceedee to prove that he is a citizen, and such provision had been incorporated in paragraph 97 of the judgment in Muslim Mandal Supra pursuant to the provisions of Article 21 of the Constitution of India. The role of the inquiring authority is merely According to MST Burman and Counsel for the Home Department, the role of the inquiring authority is merely to give an opportunity to the suspected proceeding. But the inquiring authority is not vested with any power to arrive at a final conclusion as to whether the suspected proceedee who was inquired is a foreigner or is not a foreigner. In the circumstance, the issue for determination before the court, one of the issues for determination before the court would be whether the report of the inquiring officer made pursuant to paragraph 97 of Muslim Mandal Supra vests the final authority on the inquiring authority to decide as to whether a suspected proceedee is a foreigner or not, or whether the report is merely an indicative in nature, which should vest a further power on the superintendent of police border to take a final decision as to whether there is a requirement to make a reference or there is no such requirement. Third, the learned counsel for the parties. The entire argument of Mr. R. Ali, learned counsel for the petitioner, flows from the provisions of paragraph 97 of the judgment rendered by the full bench in Muslim Mandal Supra, and for the purpose is extracted as below. Muslim Mandal Supra. Yes, Muslim Mandal citation is State versus Muslim Mandal 2013 1 GLP 809. Paragraph 97 of the judgment in Muslim Mandal Supra flows from the requirement of a fair investigation and fair trial being the basic fundamental human right of a person, which are concomitant to preservation of the fundamental rights of a person under Article 21 of the Constitution of India. Paragraph 97 itself provides that in case a person concerned, itself provides that the requirement of making an investigation is in furtherance of the principle of affording the person concerned an opportunity to show before the investigating authority itself that the person is not a foreigner. It has been provided that That upon making the investigation, there would be a requirement of a just check out the last line. Yeah. It is also provided that a fair investigation and submission of a proper report on such investigation to the authority would ensure the authority would be a requirement. And further, that such investigation need not be a detailed or an exhaustive one, keeping in view the nature of the proceedings before the tribunal and the objective sought to be achieved. The very provision in paragraph 97 itself, that such investigation need not be a detailed or an exhaustive one, in view of the nature of the proceedings that would follow before the tribunal and the objective to be issued, itself is an indication that any report that the investigating authority may submit would not be a conclusive of the fact to be determined, that as to whether the person who had been, that whether the prospective proceeding is a foreigner or not. Under which provision the SP is to make a reference? Can you recollect? Bolo.
Lordship is under the INDT rules 1984.
No, you can't go to that. It's already gone.
Foreigners orders them.
Foreigners Order 1964, I think. Clause 2 of the Foreigners Tribunals Order 1964 provides that the central government may by order refer the question as to whether a person is or is not a foreigner within the meaning of the Foreigners Act 1946 to a tribunal to be constituted for the purpose for its opinion. We have been, it is stated that the central government by an appropriate notification had delegated its power under clause 2 of the Foreigners Tribunals Order 1964 to the superintendent of police border of the respective districts to make any order referring the question on the citizenship of a person to a tribunal constituted for their purpose for its opinion. The provisions of clause 2 of the Foreigners Tribunals Order 1964 makes it explicit that it is the superintendent of police border who would be the appropriate authority to take a decision based upon the report of the inquiry or any further materials that may be available as to whether a person concerned is required to be referred to a tribunal for its opinion as to whether he is a citizen or not. A reading of the provisions of clause 2 of the Foreigners Tribunals Order 1964 as comma, as indicated above, comma, also leads to a conclusion that the report that the investigating authority may have submitted as to whether the suspected proceedee is a foreigner or not would be merely indicative in nature and cannot be said to have attained a finality on the status of a person, whether he is a citizen or not. From such point of view, we are unable to accept the submission of Mr. R. Ali, learned counsel for the petitioner, that as because the inquiring authority in the instant case had given a report that the petitioner is not a foreigner, therefore, the superintendent of police border did not have any jurisdiction to make a reference to the tribunal for an opinion as to whether he is a citizen or not. And accordingly, the reference itself made is a defective reference, which is required to be returned back. The concept of returning back the reference is being submitted by placing reliance on the judgment of the division bench rendered in Monowara. This thing, did I describe it earlier? No? I think it's described Monowara Khatun Supra, Monowara Khatun Supra. I think we already said it. Monowara Khatun Supra. In Monowara Khatun Supra, in the relevant paragraph, it had been provided as extracted. Write this much. Page number 5 or 6. In the matter of Monowara Khatun Supra, the factual situation was that the superintendent of police border, after proper application of mind on the report of the inquiry officer, came to a conclusion that the suspected proceedee therein did not appear to be a foreigner. In other words, it was the superintendent of police border who had arrived at such a conclusion, and no finality was given to any report of an inquiring authority. In the instant case, it is noticed that although the report of the inquiring authority may be that the petitioner is not a foreigner, but the superintendent of police border, upon going through the materials on record, did not arrive at any conclusion that the petitioner is not a foreigner, which again also impliedly flows from his conduct that he had made a reference to the tribunal for rendering an opinion on the said question. On facts, we notice that the inquiring authority in its report dated the date of the report, and in its report, I forget about the date. In its report, had stated that during the inquiry, the petitioner had produced a voters list of 1966, which belonged to his father, and therefore the petitioner is not a foreigner. We are constrained to observe that a mere claim by a suspected proceedee by referring to a voters list, claiming a person there to be his father, is not a conclusive proof that the person had discharged the burden that he is not a foreigner. further, there is also a requirement to prove that the person who is reflected in any voters list that is relied upon is actually the father of the person as claimed, which has to be substantiated with further material. From such point of view, the report of the inquiring authority on its own cannot be viewed to be conclusive in nature based upon materials on record that the petitioner is not a foreigner. From such point of view, we do not notice any infirmity in the reference made by the Superintendent of Police Border Kamrup to the Foreigners Tribunal. To the which tribunal? To the Foreigners Tribunal number 2, Kamrup Metro, for rendering an opinion as to whether the petitioner is a foreigner or he is a person. Whether the petitioner is a person who entered the state of Assam from the specified territory on or after 25/3/1971. In view of the above, we do not notice any infirmity in the order dated 23/20/23 of the tribunal. Accordingly, the writ petition is dismissed. The petitioner to appear before the tribunal on so and so to prove his case on merit that he is not a foreigner.
Case is fixed on 15th of this month. 15 March.
You appear on any date you feel like. Sorry.
On-
But
appear-
this order will get it on Monday. It's a
Will appear and
longish order.
submit
It
our
takes some
reply,
time.
my lord.
Okay,
That
sorry.
of the kindly given.
Sorry.
Will appear and submit our reply, madam. Written state. Because
And,
case is fixed on
prove
this-
his case on merit. And to prove your case on merit, you can do anything you feel like.
Due to pendency of the case, my lord, the tribunal
Mr.
has
Ali,
fixed on necessary
we
order.
have allowed to prove your case on merit.
Look.
And for the purpose, whatever you are entitled to do under the law, you'll do it. If I write one line written statement, tribunal tomorrow will say, High Court never asked you to file evidence. If they reject it, what will you do? So you do everything you are entitled under the law. That inquiry report dated 28/3/2001.
Yeah, please, Lord. My lord, in this case, my lord, the OP, my lord, appeared and adduced her evidence. Thereafter, my lord, she could not appear, my lord, due to her financial hardship. My lord, also, my lord, miscommunication with his counsel. So, my lord,
We have noticed two words you said, financial hardship. Do you want to preempt the cost to be imposed
yes,
by saying financial hardship?
I'm agree, my lord.
How much
The-
cost will you pay? You will pay cost. We are following
3,000, my lord. She is 67 years lady, my lord. 3,000, my lord. And
three. Heard Mr. S. Ahmed. Kali, they appeared later on. 3,000.
obligement.
Item 10,
It's Mr. Khan.
May I please, your lordship?
66,
66 lordship,
number 25,
25 lordship.
Sindhu Rai. And who is
And
the father? Baburullah.
grandparents, lordship, 25 grandparents,
Sorry. Grandparents.
my lord,
Baburullah is the grandfather
my lord.
and grandmother.
Both are grandmother, lordship, two grandmother,
Who is Baburullah?
my lord.
What man?
And
What are you saying, Mr. Khan? Who is the grandfather?
my lord,
What is the name of the grandfather?
ये my lord, Babu,
Baburullah.
Baburullah Sheikh.
He is the
Sheikh-
grandfather.
Sheikh, in case of the lordship, Sheikh only yes is said here. In subsequent.
It's okay,
vocabularies,
you don't have to
uh,
explain.
my
He is the
lord.
grandfather, no?
In the
And
subsequent-
who is the grandmother?
My lord, Neto Bibi,
Neto or Habijan? Neto,
my lord, grandmother, Neto Bibi, lordship.
Neto, grandmother. Now, who is the father?
My lord, father is lordship, your lordship will find at page 28.
28. Chindurai.
Niyamut Ali,
Niyamat, father.
father.
Baburullah, grandfather. Very well. Neto, GM. Now, which document so Niyamat is the father?
My lord, father and petitioner name appear at page 33.
Page 30? 33.
Ambiya Khatun. Niyamut Ali, Nasimun Bibi, father and mother. And petitioner name appear Ambiya Khatun.
Yes, sir.
I think it's for the first time.
First time I know, but it's very clear. And she is 18. Ambiya Khatun is 18 years. Yes. And Niyamat Ali, his name is consistently appearing earlier also.
Same village.
Same village. Why trouble these people? Should you finish it up here only? Oh, we do one thing, we list it next week. You just examine it. Instead of issuing notice and or sending back, let us finish it off. Baburullah as son of Dhero of the 1966 voters list of village Chindurai Part 2 is claimed to be the grandfather of the petitioner, and Neto Bibi to be the grandmother. Niyamat Ali of the 1971 voters list of village Chindurai Part 2 at serial 134, whose name again appears along with Baburullah Sheikh and Neto Bibi, is claimed to be the father of the petitioner. The name of Babar Ali Neto Bibi what happened to Niyamat Ali in 85? Appears in a voter list 85, but Niyamat Ali's name is not available. In 1995, of the same village, the name of Niyamat Ali, son of Babar, appears. And thereupon, reliance is placed upon the voters list of 1997 of the same village Chindurai Part 2, which contains the name of Ambiya Khatun, the petitioner, along with Niyamat Ali. Mr. Ali, where is he? The election department to produce the complete voters list of village Chindurai Part 2 from 1966, 71, 77, 85, 1995, 97, 95, there will not be 1997 and 1997 for examination of the court. List on next week.
Some protection.
Okay. Protection, you are protected, don't worry. We are thinking of declaring you to be a citizen.
15 June.
We are thinking you of declaring you to be a citizen, don't worry. Burma, don't take this girl to custody. It's a very, appears to be very clear. Let us examine the complete voters list. Hmm?
The siblings' names do not figure in the voters list, the brothers,
Therefore, you want the complete.
yes, because there are other siblings also. How come only the daughter figures with the
So
father?
let us examine the complete voters list. That will throw some light. Next. please.
Item 11,
No coercive action against the petition.
My lord, this matter may kindly be taken after some time, my lord. Mr. Goyal will appear, my lord, after some.
item 12,
On 11/4/2023, when the matter was called, none appeared for the petitioner. But it was adjourned with an observation that in the event of subsequent non-appearance, adverse order shall follow. Today, again, when the matter is called, none appears, dismissed for non-prosecution.
item
The dismissal
13,
of the writ petition be informed to the Surrender Police border of which place for necessary action. Second. Or Borpeta, maybe. Borpeta, SP Borpeta. What will be? The petitioner may file restoration petition if so advised. It will accurate. Yes, 13.
In this case, your lord, the petitioner own name has appeared in the voter list of 1971.
71, own name,
Page 13, your lordship, type copy.
page
14.
13.
Kuzrot Ali, son of Shahid Rajan. Age 21 years.
Son of Sahib, village, Mokhwad.
Move forward, sorry.
We pass a one paragraph order. Let it go back. Respondents will examine whether this Kujrat Ali, son of Sahib or Mokhwa Chor and the writ petitioner Kujrat Ali, they are same person. Third, Mr. What should we do this one? Third, Mr. S. Islam, Land Council for petitioner. The petitioner Kujrat Ali had been referred to the Furnace Tribunal number 2, Bongaigaon at Ohayapuri for rendering opinion, resulting in registration of case number BNGM FT/1356/2007. Tribunal rendered an opinion dated declaring to the 36/2018. In the writ proceeding, the petitioner relies upon the voters list of 1971 of village Mokhwa Chor, police station Bagbor in the present Borpeta district, which contains the name of Kujrat Ali, son of Sahib at serial 1043. It is claimed that Kujrat Ali of the 1971 voters list is the petitioner himself. In view of such claim, remanded back to the tribunal to enable the Home Department of the Government of Assam to make a verification as to whether the writ petitioner Kujrat Ali and the Kujrat Ali of the 1971 voters list of village Mokhwa Chor are one and the same person. A further verification be also made on the authenticity of the voters list of 1971 of village Mokhwa Chor. Full stop. Upon doing the needful, a report be submitted before the tribunal, and based on the report, a reason order may be passed.
SP, Lordship SP border, Bongaigaon to.
Bongaigaon,
conduct the
SP border
inquiry.
Bongaigaon to make a verification.
I'll take a copy of this order.
Sorry,
I'll have a copy of this order.
okay, a copy of the order to appear on so. They'll only verify whether firstly the list is an authentic list or not. And secondly, whether
Same person.
same person or not.
Okay.
item 14,
Jasmat Ali.
Jasmut Ali, Lordship, the petitioner,
Hmm.
Lordship, the petitioner grandfather, mother and father name is recorded 66, Buddha list, page 37.
Page 37.
Particular is 38. Zovidal green.
3766, village Baliguri, Nongke.
None. Zovidal is grandfather.
The voters list is original of 1966 of village Baliguri, Nongke be produced by the election commission on the next returnable date. List, next week? Verma,
Yes, Lordship.
next week,
Next week, we'll have to
Maybe
tell
Ali.
it to Ali.
tell him a copy of the survey we made available. A2 heritage site vote.
Item 15.
May I please, your lordship? Lordship, in this case, Mr. M. Sutia was earlier engaged in this case. Subsequently, I have been entrusted with this bill, but I could not file the vocal command. One would take-
Mr. B. Chandal and council states that although earlier Mr. M. Chetia was appointed as a learned counsel for the petitioner, but at present the brief is being handed over to Mr. Chanda and he requires some time to file the Wakalatama
Lordship.
for doing the further needful. May I allow? List, sir.
16 for orders.
May I please, yes, your lordship. Lordship, this I is for extension of time, for FRS
Page,
report,
where is the order of the court?
lordship, page, 9 to 32, page 9 to 32,
Page,
9 to 32,
sorry.
9, page 9, lordship. is the
Nine.
order.
It's a huge order.
Yes, relevant, para is at, 31, lordship, para 49. Wherein the honorable court directed us to appear before the.
Why did he pass a 24-page order?
Maybe Lordship had taken up a full length hearing and just.
Some issue was decided possibly.
Looks like that, Lordship.
Anyway. Page 31, appear on 11/5.
Yes, lordship.
Your, what Chakma, your name?
SK Chakman.
SK Chakma.
Yes.
I heard Mr. SK Chakma and counsel for the applicant. This application is instituted for extending the date of the petitioner before the tribunal as provided in the order dated 21/3/2023 in WPC 5307/2020. In paragraph 49 of the said order, it was provided that the petitioner shall appear before the tribunal on 11/5/2023. For reasons stated in the application, the petitioner seeks for an extension of the said time earlier granted. Prior to petitioner allowed, the petitioner shall now appear before the tribunal on what date you want to appear. You choose your date.
15 more days.
15 days.
So you choose your date, whatever, but this time please appear.
By the end of this month.
Yes,
30th
lordship.
June.
Sorry,
30th June.
30 June.
30th June.
কি বললো? Shall now as paid for by the petitioner. The other provisions of the order dispensary shall remain as it was provided earlier, except that the petitioner shall now appear before the tribunal on 36/20. I allowed as indicated above.
Deeply
I allowed
obliged.
to the limited purpose as indicated above.
I am obliged, Lordship.
Item 17 for hearing.
Mr. Das.
May I please, Lordship? I think there is an order on the last occasion, that is 30th of May, my lord.
Sorry.
My lord,
Lordship,
affidavit could not file lordship, some time may be allowed.
Adjourn on the prayer of Mr. G. Sharma and counsel for the Home Department to do the needful as required by the order of 35/2023. Ms. Thompson.
20th June. Item 18 for motion.
G. Sharma. None appears for the petitioner when the matter is called next week.
Item 19.
May I please, your Lordship?
Why is-
Marcelo 19.
Sometimes they have to-
He-
possibly the one who has- What do you do? none of you, Sir Panovich, this thing. It is noticed that the requirement of the order dated 22/5/2023 had also not been complied with by the petitioner.
Our presence may be recorded, Lordship.
So what did we do? Yes, Mr. Am I Hussain?
May I please also, my lord, page 20. The list of 1966, appearing the father and mother's name.
Why is it listed for motion?
My lord, the notice was issued earlier and record was called for also,
Notice.
and fixed for today.
Okay. Now, which page?
Page 20, Lordship. Voter list of 1966, appearing father and
66,
mother.
Village Goroimari, and who is the father?
Serial number 3, Lordship.
Three,
Father,
Amar Ali.
Amar Ali. and
Amar
4
Ali
is the
father,
ma-
son of Gafur, Jaheda mother.
Yes, Lordship.
Ah.
My lord, 70 also same, voter list of 1970 also same.
Same.
Lordship. Lordship.
Okay,
Then Lordship, Kabin Nama Lordship at page 30,
page
page 30, 30,
30.
Lordship.
Kavindama issued by whom?
Kazi Lordship.
The government Kazi.
Yes, Lordship.
Yes, what to do? Madam Rama,
Yes, Lordship.
What would you-
Kabin number was,
Lordship.
because the one or two marriage register are also faulty, what we found. We accept it as it is, sent back, or we call for the origin,
this one,
Lordship, in this-
it's just a new matter, Lordship, 23 matter. So
call for the
all-
origin.
this-
Reliance is placed on the Kavindama at annexure 7, page 31 of the writ petition, which contains the information that Kulsum Begum is the daughter of Omar Ali of number 3 Goroimari village. The marriage registered in original of the authority issuing the Kavindama be produced. A copy of this order be provided to MS Verma, and also Home Department for doing the need.
SP border Bogaigaon.
Be produced through the Superintendent of Police border. Which place?
Bogaigaon, Lordship.
Bongaigaon. Copy of the full list on
22nd June.
Lordship may
Lordship,
even
Kazi-
mention SP Borpeta because it's written Sorbo. So both the SPs will.
Bongaigaon বলেন কি? Bongaigaon
Borpeta.
or Superintendent of Police Borpeta as the case may be. Suppose the information comes is correct, we'll finish it here only instead of sending it.
Yes, Lord.
And if it is defective, consequence,
Kazi was not examined, Lordship.
not required. Now he will take the place of the Qazi.
Lordship.
If we have the original records, what will the Qazi do? Qazi will depose on the basis of original records,
Some
No.
other materials are also there, Lordship. It has
not required anymore.
Yes, Lordship.
Everybody examine the origin register here itself.
Obliged, Lordship.
If any doubt arises, we'll send it back. Yes,
Item
Mr.
20.
Krishna. Inquiry report of the referral authority be produced before the court. Further procedure. Do you have the inquiry report?
From FT, we have got something.
No, earlier order was inquiry report of the referral authority under memo number so and so be produced before the court.
We have received it from the FT member, Lordship. But it's all in vernacular, so maybe next week, Lordship.
I have annexed the certified copy, my lord.
Where?
My lord,
Then why
page-
did he
page one-
pass that order if the certificate?
Last date, he said he couldn't get it.
No,
Oh,
Lordship,
that is- what was it?
my lord, page 106.
Lordship, this had to come from the records or from the police, Lordship, because it was not clear from where to obtain the true copy of the inquiry report.
I think the SP will have a copy with him. In
they
one
retain
file
a
must be
copy.
retained there also.
We can again try to get it from the SP, Lordship.
And which page you are referring? 10?
My lord, 106.
106. What is it?
Vernacular matter. And translation is page, my lord, 104.
104.
4.
What? No, what is this 106? To Srimati Lodha Upadhyay learned attached member. Inquiry report.
Lordship, there
Just
is
a
some
minute.
thing here, the person is same, but he has changed his name. Lordship, can we get a translated copy of this?
104, please.
He had made a translation 104.
I'm just going.
If it is the same copy, just check out.
Yes, Lord. Is it really close like this? I'm not deciding.
So he said after inquiry, it is known that Akhtar Banu and Mokhale Azam are one and the same person. Inquiry report dated 16/9. Is this the 16/9 report?
Yes, your lordship.
No, page 104, is it dated 16/9?
Yes, your lordship, 16/9. 16/9.
So the confusion is whether Akhtar Banu
And
and Mokhale Azam are same, because they proved the case as Mokhale Azam.
And the police has also certified they are one and the same.
One and the same.
My lord, can you see page 111, my lord? One Mokida Begum, first name also appeared in the my lord inquiry report. The sister,
That we have already seen.
my lord,
Mokita Bibi.
she, my lord, shown an affidavit, my lord.
Since it is an ex parte order lordship, it can be remanded back and let him go with their lordship.
Not finalized, my lord. The proceeding is going on.
Then
So why did
why
he come to
you-
the court then?
My lord, I come to the court because I am not Akhtar Banu, I am Mokhale Azam. And I filed petition before the, my lord, Lanet Tribunal, that I am not the proceeding, my lord.
No, but the report
That was-
says Akhtar Banu and Mojila are the same person. Now he's taking
No,
a
my lord.
different
I
stand.
have,
No, who said they are different person? Tribunal?
He's
no,
saying,
my lord, tribunal said that both are same person. Kindly see the impugn order,
No, if both are same person and you are Mokhale Azam,
my lord.
then your purpose is served.
No, my lord, my petition was rejected, my lord.
Which petition? Where is that order?
My lord, order is, my lord, page, my lord,
one, I think is referring to that.
my lord, impugn order is page, my lord, 95, my lord,
95.
95. I file an application.
Just a minute. Petitioner represented by on the cost.
95 to clear, no. 95.
Order.
What the page you need me to Lordship, we are not on the same page with the peer, Mr. Lordship.
So you are a Mokhale Azam.
Yes, your lordship.
To whom was the notice served?
My lord, I have been served, my lord.
Not I. Name.
Notice served to the Akhtar Banu, but the notice handed over to me, my lord. Kindly see the notice, my lord. Kindly see.
Notice is in the name of Akhtar Banu.
Akhtar Banu.
notice is served on this Mokhale Azam,
Yes, your lordship.
and you are Mokhale Azam.
Yes, I am Mukhale Azam. Page 90 is,
And his sister is Akhtar Banu. That is the what we report. He'll explain better. It's all in vernacular.
well, page
His
90.
sister is Akhtar Banu.
Our home sister has explained before the concerned police officer lordship that Akhtar Banu and Mukhil Azam are same in one person lordship. Own sister lordship.
No, my lord, affidavit, she said that the
Let him go before the
police,
tribunal. and prove their-
police go and.
their-
No, no. Where is the reference order?
No reference.
Where is the notice?
Notice is page, my lord, 90,
90.
90.
Akhtar Banu.
Akhtar Banu.
So,
And husband name is Amjul.
so Mr. Sharma, how we understand, a notice addressed to Akhtar Banu
My lord.
had been served on this Mokhale Azam. Okay,
Yes, lordship.
now you want to proceed against Akhtar Banu or you want to proceed against Mokhale Azam?
We. Yes, lordship.
Again, whom you
We
intend to
have
proceed?
to proceed against Akhtar Banu lordship. as
Akhtar
per
Banu,
law.
you proceed against Akhtar Banu, don't trouble Mokhale Azam.
But they are the same person lordship. Police.
If they are
says
same
lordship.
person,
This report,
Okay.
the lordship will
After-
if they are same person, from where did you get the name Akhtar Banu?
Yes, lordship. I have read the vernacular lordship.
Understand, where did you get the name Akhtar Banu then?
Lordship, they have went to the village of Akhtar Banu lordship. Then.
No, no, if
somebody-
Akhtar Banu is not there,
Yes.
It-
Earlier Akhtar Banu was there lordship.
so now what happened to Akhtar Banu?
He has gone to another village and sends his name
Okay,
lordship.
Akhtar Banu went to another
Another village
village
and sent
and
his
now
name.
assumed the name Mokhale Azam.
Yes, lordship. That is the inquiry report lordship.
Lordship.
That is the.
Is
report,
it so, Mr. Islam?
No,
Where was this person earlier known as Akhtar Banu?
No, my lord.
Never.
No, never. I have never been Akhtar Banu of Kakripara or Akhtar Banu of Kathalbari.
Lordship, either we
I am
believe,
Mukhale Azam of Kathalbari. my lord.
either we believe the police report or we believe the petitioner. Lordship may, it's in vernacular, lordship may have a.
My lord, kindly see page 112, my lord. My lord, affidavit shown by Mofida Baby.
112.
112, my lord.
So
relevant
we have read
officer.
that. That Mofida Bibi is a sister,
My lord, sister of
the Mokhale Azam.
I have shown affidavit lordship.
para 3, my lord.
117, 106, no? Mr. Sharma, police thinks initially it was Akhtar Banu in one village.
Yes, lordship.
Same person shifted to another village, became Mokhale Azam. Okay,
Yes, lordship.
and submits a report that Akhtar Banu and Mokhale Azam are the same person.
Yes.
Mokhale Azam states before the court that I was never Akhtar Banu. I am all along Mokhale Azam. Now what do we do?
Yes, lordship, a police report on the basis of the statement of the sister of the Mukhale Azam lordship. That is Akhtar
No,
Banu.
that
lordship.
doesn't mean Mokhale Azam will become Akhtar Banu because some sister has said it. Suppose your brother today makes a statement that you are not G. Sharma, but you are Mr. M. Sharma. Will you become Mr. M. Sharma? We all know you are G. Sharma.
Or we can do.
How do you resolve this?
We can ask both of them to be present in court. Mokle also and Akhtar also, and the police officer.
See,
Mukhale is present. my lord.
one would have,
Mukhale Azam is present before the honorable court.
No, in
Madam
person,
Verma,
not
if
you.
you pass that order, one of them has to be in a ghost form because
No,
he says it is one
no,
person.
when I said both the persons, he's saying it is in.
Madam, suppose I
petitioner
passed,
before this.
suppose I passed a order, both person remain.
Hmm.
Mokhale Azam will remain,
Remain.
but Akhtar will have to present in a form of a ghost.
Exactly,
if the-
lordship, we need to see now
So,
what is correct,
so how can we issue a direction to a ghost to come and appear?
because they, our report says the sister said that she changed the name. Either there are two people or there are one person, or the police is lying or the petitioner is lying. something is wrong somewhere, Lordship. It
I
cannot be
understand
like
that.
this.
And reference also made Akhtar
Let
Banu, my lord.
let the police bring them
Case
both here
96.
if they are existing, Lordship.
No,
Only
sister says
after-
actually I do not know who is Akhtar Banu. Mokhale Azam and Akhtar Banu. Sister says they're different person. Come to page 112. He doesn't say same person. Where is the original report?
We submitted that.
No, this is the inquiry made subsequently, I think.
Lordship, can it be on next week, Lordship?
We'll get the original report. And if required, Lordship may even call for the petitioners. and
The records in original from the Superintendent of Police border. Which place? South Salmara Mankachar be produced before the court. Which should contain the report of the inquiring authority as well as the order of reference of the Superintendent of Police, so as to ascertain as to against whom the reference had been made. Against whom the inquiry and the reference had been made. Meaning thereby it was against
After all,
Akhtar Banu or it was against Mokhale Azam.
and even to ascertain whether there are these two people or not. Or
The
only one
Superintendent of
person.
Police border to make a fresh inquiry through a fresh inquiry to Nalai and submit a report as to whether Mokhale Azam and Akhtar Banu are one and the same person or they are different persons, or on fact, Akhtar Banu does not exist
Yes,
and it is only Mokhale Azam who exists.
yes, let it be
Let
clear,
it be
Lordship,
clear.
because they have so many names. It becomes difficult for everyone.
There is a report by inquiry report dated
16/9.
uh, page 16/9/2022 of the inquiring authority that Mokhale Azam and Akhtar Banu are one and the same person. On the other hand, the petitioner Mokhale Azam has made a categorical statement before the court that she is only Mokhale Azam and was never known as Akhtar Banu. Full stop.
And Ajam, her aliases is Ajam, Lordship. Mokhale, Ajam, aliases Ajam.
Azam, my lord, one spelling, I have missed the A and O.
Whatever it is, there is another name you have.
Keep it ready.
Lordship, after 10
List of
days.
next week,
After 10 days,
10 days. okay.
yes, and a copy of this order may be served to us, Lordship.
Hmm. Hmm. That will already called for. Report of the inquiring authority as well as the reference made by the SP. On the basis of which notice. Is a report of the inquiry here and the reference. Based upon which the notice dated 35/2022 at page 90 of the repetition will be put
Copy of this order may be served.
next Friday. Because there will be continuity.
If this order is uploaded today, we can also.
A copy of the order.
16.
Highly obliged, your lordship.
Hmm. Yes, Mr. Mahmood, you are for which matter?
Actually, I have given Lordship, can you see in the chamber?
What is it? No, it's it now. Nothing in chamber. Everything here in the court.
In chamber it will do, my lord, nothing.
That Justice Ujjal Bhuiya's judgment.
Your Lordship judgment one, and one was with.
That what, when a man dies, that he has to be
it was-
returned back, that one.
It was debated, and it was observed.
No, no. That's why it's a safer proposition of law.
Ah,
That will be a very unsafe order.
yes.
Because if once it is returned back, the suspicion that the man is a foreigner or not will always remain.
No, that is no problem.
So
but
best thing
I
you,
only wanted to say,
best thing you clear it get the legal heirs substituted. Through them, they will prove whether their father was a citizen or not. If the father is a citizen, their problem is also over.
That I,
If the father is not a citizen,
that I will. do that.
consequent. I think that is a much safer
Yeah,
option.
but-
And
Here
let
it
us
was observed that
and
fresh
let-
reference should be there.
understand, let us remove this confusion. I know that earlier,
Yes, yes, yes.
this thing, but that is again on some other context. We have gone through everything.
Your lordship's two order and one order will my lord justice.
Understand?
Koteshwar Singh's.
But that time, therefore, in the absence of separate reference education, merely because they are directly related to it.
A separate proceeding is
No,
necessary.
these are right. Accordingly, opinion, separate.
Separate, yes. That
So
was
it-
also my.
So instead of now separate proceeding,
Yes,
what will be the difficulty with you know? This final order against your father will remain. You will have to prove your citizenship through your father,
Apply.
and the father will become a foreigner. That will be an obstacle against you, which you can never remove.
I will take
So-
instruction on Monday, I
Huh.
will say.
So you better remove the obstacle, get them substituted, so that the citizenship of the father can be given a final consideration. We are aware of all this, but this is not the answer. Okay, because father will remain a foreigner forever. No one can touch with that order. And the sons will be in a,
In the real.
There will
order,
be a-
Father's order.
there will be a block in front of them which can never be removed. And the son cannot prove his citizenship independently, divorce the father. Every citizenship is proved always through the lineage, not independently. No one can prove I am a citizen or I am not a citizen. Everyone can prove I am a citizen because I am son of so and so village, who admittedly is a citizen, or that man, in fact, on the other hand, is a son of so and so village, who is a citizen, and therefore, by following the lineage, we are also citizens. That's the only way you can prove it.
Monday, I will, after taking instruction, I will file petition.
See, Mr. Mahmood, we are always trying to give the best opportunity to the litigants that their entire legal issues are protected. That's true.
Yes.
Intention is always to do complete justice to these people.
Yes, sir.
But sometimes,
That-
without forcing what may
We are
come,
human being.
without forcing what obstacle may come, a lot of arguments are made in exuberance. And when we come across that, we put it more strongly against you. Because today, Mr. Mahmood may have made this submission, but it will go against the interest of the litigant before the court. And we are constitutionally bound to protect the rights of the litigants. That is a superior duty
Yes,
we
yes.
are exercising.
Yeah, well, but
Then
for
merely
lawyer, the litigant should not suffer.
that merely trying to satisfy a given learned counsel in a given circumstance or not.
Okay.
Yes, Mr. Goyal, you have
My
any
lord,
matter?
item number 11, my lord, I am in.
What happened to 11?
My lord, I want, my lord,
Timing.
I am in the midst of hearing in another court. my lord.
Okay, time.
Not today, my lord.
Item
Monday.
of the affair of Mr. Goyal, 11 to liquidate, and this comes next. 21 you are appearing?
22. No, item number.
Mr. Sarkar, 22 item. Mr. Sarkar, what is your matter?
Item number 21, Lord.
You have to do it today or next week?
Yes, your lordship. Next week.
Next week. Let's wait for this one.